Before today's episode, a quick message. This is Mark, and I'm the creator of Lantern Podcasts. I'm really looking to talk with more of our listeners to get a sense of what you honestly like and dislike about these shows. So if you'd like to chat, please shoot me an email at hello@lanternpodcasts.com, and I'd love to speak with each and every one of you. Thanks. Now on today's episode.
Judge Gonzalez Rogers looked at OpenAI's summary judgment motion and basically said, "Not so fast." That January 15 order is why this case ever got to a jury.
Welcome to Musk vs. Altman Daily. I'm Devin, she's Cassidy, and today we're finally cracking open Document 390, the ruling that split Microsoft's fate right down the middle.
We've got the summary judgment order in hand. 28 pages. Northern District of California. Dated January 15, 2026. And it changed what the trial was even allowed to decide.
OpenAI denied, Microsoft split. Let's get into what actually survived.
The source writes,
This action arises from a contentious dispute between Elon Musk and Samuel Altman and their respective companies over large charitable donations that Musk made to OpenAI Inc. during the company's infancy and Microsoft's later investments in OpenAI Inc.'s for-profit ventures. Defendants Altman, Greg Brockman, and the OpenAI entities, collectively OpenAI defendants, move for summary judgment on Musk's claims for breach of charitable trust, constructive fraud, promissory fraud, and unjust enrichment.
Document 390, filed January 15, 2026. Judge Gonzalez Rogers denied OpenAI's motion for summary judgment outright and split Microsoft's motion. Granted in part, denied in part. On OpenAI, that's the hard stop. The court found genuine disputed material facts on breach of charitable trust, constructive fraud, promissory fraud, and unjust enrichment. In plain English, the judge said a jury has to hear this.
And the Microsoft split is the part I want pinned down because granted in part, denied in part means at least one of those theories against Microsoft, tortious interference, aiding and abetting breach of fiduciary duty, unjust enrichment, made it through to trial. Which one?
That's exactly the right question, and it matters beyond this case. Whatever theory against Microsoft the court kept alive is now sitting in the public record at docket numbers 327 through 368. And Judge Wang in Copyright Court is already looking at that briefing for inconsistencies. Summary judgment didn't end this. It built the record the jury worked from, and that record is reusable now.
And this order is dated January 15, 2026, which means while Judge Gonzalez Rogers was buried in briefing, OpenAI was also running restructuring and IPO prep. Karen Howe's sources called that period controlled chaos inside the company. Now we can actually put a court date next to it.
From Courthouse News Service.
The relief requested is extraordinary and rarely granted, as it seeks the ultimate relief of the case on an expedited basis, with a cursory record and without the benefit of a trial. Having carefully considered the papers submitted and the pleadings in this action, including oral argument, and for the reasons set forth below, the court hereby finds that plaintiffs have failed to meet their burden of proof for the extraordinary relief requested and denies the motion.
Today's document is Document 390. Judge Gonzalez Rogers, January 15, 2026, case number 424 CV 4722YGR. And the headline is simple. OpenAI's summary judgment motion was denied. That's not housekeeping. That's the court saying disputed material facts exist, and a jury needs to sort them out.
Wait, so this order drops January 15th, and OpenAI is doing IPO prep and restructuring at the exact same time? The court is deep in summary judgment briefing, while the company is rewriting its own governance structure. Yeah, that's a pressure cooker.
That timeline compression is now documentable, and that's the key word. We also have to account for the Microsoft split. Their motion was granted in part, denied in part, which means at least one theory of liability against Microsoft cleared summary judgment and survived into trial. And the briefing record, docket numbers 327 through 368, is now a named public record.
And that briefing record matters downstream, because those are the sworn statements Judge Wang's copyright court can now hold up against whatever OpenAI's witnesses say there. You survive summary judgment on one set of facts. You don't get to tell a different story in the next courtroom.
If you're tracking Musk, Altman, and the race to scale AI, try the Data Center Daily, a daily briefing on AI, compute, hyperscaler, CapEx, power, chips, and energy markets. Find it wherever you listen to podcasts. If you want to dig further into anything we covered, you'll find links to all of today's stories in the show notes. Take a look there for the pieces that caught your attention. That's Musk v. Altman Daily for this Friday. This is a Lantern podcast.